It's very good to have you here. So what we're going to do here this afternoon is really pick up on a theme that's been central, actually, to the forum, but pick up on a particular strand of it, which is multilateralism, but in the form of multilateral treaties. We've termed it the nuts and bolts. I think, as you'll see, we're going to get into a lot of different themes about treaties, including, I think, the very basic question of whether reports of their deaths has been greatly exaggerated. Part of our nuts and bolts discussion is going to be to talk really basic about first principles, about how multilateral treaties get launched, negotiated, concluded. We'll talk about some legal and political drivers. We'll talk about where we can actually speak to some lessons learned, where are treaties successful, where are they not in terms of negotiations. And we're going to do that with the benefit of some amazing experts here with me that have firsthand knowledge of some recent treaty-making efforts. And so we'll go through that. We are structuring this very much as a discussion and roundtable. So with their prior approval, I'm going to be extraordinarily brief in terms of introducing them. And then we're going to launch right into the Q&A. But sitting next to me, Sean Murphy, obviously president of the Society and at GW Law School. We have Cymie Payne at Rutgers Law School. I should mention Sean will be focused on the possible Convention on the Prevention and Punishment of Crimes Against Humanity. Cymie is going to address the possible Convention on Marine Biodiversity of Areas Beyond National Jurisdiction. We have Hal Abramson from the professor at Touro Law Center, and he'll be addressing the Singapore Convention. And Michael Coffey from the Office of the Legal Advisor, Treaty Affairs, who will speak to the 2019 Hague Convention. So again, let's start from the beginning. I want to talk about origins. I think as everyone here knows, there's lots of places that multilateral treaties can start, and international organizations can play key roles. If you look at the treaties that are on the table today, you have, for example, the UN General Assembly creating the body negotiating the BBNJ Treaty. The ILC taking a look at the Crimes Against Humanity draft articles. The Singapore Convention came out of Untitled, and the Hague Conference drafted the Hague Convention. So I want to talk to each of you about where your treaty came from, and including your views about how the origins of your treaty impacted the art or the exercise of treaty making in your view, and including what prior steps were taken. So Michael, let's start with you. If you want to start us off in terms of origins and some of the dynamics there.
Thank you, and thank you for the intro, and thank you for having me here. At the outset, I should state that all views expressed are my own. Hopefully there might be some overlap between that and the department, but this is all mine. So for those of you who are not aware, the Hague Conference on Private International Law focuses on conflicts of law on the international plane, and or also referred to as private international law. In 1971, there was a convention concluded on the recognition and enforcement of foreign judgments in civil and commercial matters. Probably not the most successful of conventions in that it has 5 states parties, those being Albania, Cyprus, Kuwait, Netherlands, and Portugal. It's great for them, for the 5. We always hope we get more participation. Parallel to the existence of this 1971 convention, you have a couple instruments in Europe, that being the 1968 Brussels Convention and the 1988 Lugano Conventions, addressing issues of recognition and enforcement of judgments. In 1992, the Department of State made a proposal to the Hague Conference in terms of what future work could be done in this area, and we proposed a convention. It took a few years for negotiations to start. Negotiations didn't start in earnest until 1996, after 1992, the governing body considering this work. Now, we looked to the Hague Conference because not just the 1971 convention, but the Hague Conference has brought us numerous relevant conventions, including the Apostille Convention, the Service and Evidence Conventions, numerous conventions in the area of family law, one that was concluded after our proposal, but was still quite relevant in that it looked at recognition and enforcement of measures of protection, for example, custody orders. So this was a body that had already had quite a bit of experience in the relevant subject matter, and also had key membership. In this instance, we found it helpful to have a body that at that time was had significant membership from Europe. In many respects, that can cut in multiple directions, and the organization has often been critiqued for being overly focused on Europe and or maybe the North, but largely Europe. But here, to the extent we wanted to address the 68 and 88 conventions, it was helpful to look to an organization that had significant European membership. The two issues that really came into play were the exercise of jurisdiction, where a lot of countries, particularly those in Europe, but a lot more globally, weren't too keen or haven't been too keen on the manner in which the United States exercises jurisdiction. But then also the issues of recognition and enforcement of foreign judgments. In the United States, we've done ourselves a disservice, perhaps, in that since the late 1800s, we've recognized foreign judgments, at least at the federal level, based on the principle of comity, pursuant to Hilton v. Gaillot. But then we also have two uniform state laws that will recognize and enforce orders. So our negotiating stance was a little bit undermined, perhaps, in that we were already giving what others in the room might want. But nonetheless, we thought it was important to try to get some benefit for holders of, or U.S. holders of judgments from U.S. courts. So in 1996, the negotiations began. There have been several iterations of these negotiations. One was completely unsuccessful, ending in the late 1990s into early 2000s. And the process disbanded briefly. Then the process regrouped, and there was work on the choice of court agreements convention, which was adopted in 2005. It was much less ambitious than what the United States had originally proposed in 1992, but it was quite successful. Then from 2005 to roughly 2012, there was not much work done in this area, but there had been a bit of interest expressed to restart work. So what had occurred there was a decision to proceed with a negotiation where the body would focus on what we thought was the most important and most achievable, that being recognition and enforcement of foreign judgments, with future work to focus on judgment or jurisdiction itself. The body had created an experts group to try to identify some of the salient legal issues that would be relevant. That body met a couple times. The work of the experts group was then presented to a working group, which prepared a draft convention. It's a smaller group of experts to prepare the convention or the text of a draft convention. Which was then presented to a special commission, that being open to all members of the organization to negotiate at the expert level, not at the governmental level as such, although the representatives or the experts were designated by governments. So in the special commission, they had multiple meetings where proposals were made. The text was cleaned up a bit. There were a lot of key issues identified that would require a subsequent political decision. So after, I think, four special commission sessions, there was a diplomatic session just this past summer where there was one final review at the government level of the text, And the result, happily, was a convention. Now, throughout the negotiations, starting from the experts group process or phase on, there had been informal meetings where you had representatives from various governments trying to meet to work out some of the more contentious issues behind the scenes. And that made it a bit more helpful when you got into the more formal meetings, be it the experts group or a working group or a special commission or even a diplomatic session, since you would have these issues resolved a bit more, so you didn't have to open them on the floor.
Thanks, Michael. So Cymie, obviously BBNJ, very different posture, but an origin at least from the UNGA in terms of a mandate. Tell us a little bit about where that's at.
Okay. I actually have a long list of all the steps that led to where we are now, and I'm not going to mention most of those. But if you're curious, you can find them in the evocatively named article, Long and Winding Road, which you can Google easily and find. So really, the story really begins with the UN Conference on the Law of the Sea in 1973, which resulted in the UN Convention on the Law of the Sea that came into force in 1994. And the subsequent UN General Assembly review annually of ocean issues led not only to repeated resolutions on the ocean, but it eventually, through several UN processes, which are the ones I'm going to skip, led to the General Assembly being presented with a proposal for beginning a negotiating process. Now, there's two things that are important about that early history. One is that the UN Convention on the Law of the Sea is, as I'm sure everyone in this room knows, not only decisive in allocating things like territorial sea, EEZ, high seas, freedom of the seas for certain kinds of activities, but with due regard for other nations' rights, the common heritage of mankind for the seabed in areas beyond national jurisdiction, and a number of other things. But although it has some detail there that's quite specific, it also is a framework convention comparable to the Climate Change Convention. And there are elements where either there are gaps or parts that need to be operationalized in protocols or what are called implementing agreements under the Law of the Sea Convention. So there's already two, one for deep seabed mining from 1994, another that's the 1995 Straddling and Highly Migratory Fish Stocks Agreement, and this would be the third implementing agreement. It really was initiated through the recognition that scientific observation of the ocean showed deteriorating conditions for biodiversity, for life in the ocean more broadly. And so this 2015 UN General Assembly Resolution 69292 set the negotiating mandate, which is briefly the scope of the agreement is it applies to marine biological diversity, and it applies only to areas beyond national jurisdiction. The overall goal is conservation and sustainable use of biological diversity, and it's got 4 elements to it that the negotiators are allowed to address. They haven't gone off the map that they were given by the General Assembly. So area-based management tools, including marine protected areas, is the chief biodiversity management strategy, supported by environmental impact assessments that require notice and public evaluation of proposed activities, and then 2 elements that are quite different. And you can see how the negotiation gets balanced. 2 conservation elements. The other 2 are the question of ownership of marine genetic resources, which are expected to be quite valuable, including questions on sharing of benefits. And the differing abilities of states to benefit from the global ocean in ABNJ is addressed by capacity building and the transfer of marine technology. So where we are now, we've had 2 years of preparatory committee meetings, and then we're into the second year of actual negotiations. The fourth negotiating session is scheduled for April, and that's what's been budgeted. So the idea is that we would finish the work then. I just want to sort of conclude with responding to this question of how the origins of the agreement have shaped it. Clearly, as an implementing protocol to the UN Convention on the Law of the Sea, it has to fit within the principles and clear rules in that agreement, in the convention. And that, in some ways, is a limitation, because when UNCLOS was negotiated, we didn't know as much as we do now about the ocean. The problems of climate change impacting the ocean weren't as recognized, and the scale of activities in the ocean hadn't reached what it is now and what it's projected to reach. So there are some constraints there, and some of the tension in the negotiation is around overcoming those constraints. I think the other thing that's worth mentioning is that the civil society role has been quite pronounced here, both civil society engagement throughout those earlier stages leading up to the preparatory committee and the negotiation, and also during the process. And it's been a highly organized effort where civil society organizations work with an umbrella organization. And the organization that I advise, International Union for Conservation of Nature, participates in that in an expert capacity. I think that's, so there's both sort of the witnessing of what you're doing and the expert advising that you see.
Thanks, Cymie. And I want to come back to the theme of constraints in a moment, but Hal, could you set the table for us on the Singapore Convention?
How many people here are familiar with Untitled? Anyone ever go to one of their meetings? 1, 2? Well, to tell you, it was all new to me. I'm here in this panel because I'm really interested in hearing the other panelists, so this is my way to get a good seat. Because this is my only experience with working firsthand on helping to draft a treaty, so I cannot comment on how unique my experience was or how much I can generalize from it, but hopefully these other panelists can give me some comparative perspective because they've worked on more than one process. For me, getting involved with this, you looked at your article, I'll pull up my article. I don't know how this fancy title is yours, I have to talk with you about that. But my experience started Friday, March 21st, 2014 at 3:54 p.m. Why so precise? Because that's when I got the email. And I got an email from somebody who I never met, knew nothing about, by the name of Ted Schnabel from the U.S. State Department. And he just said, we're thinking of starting a project here on a treaty or a process. They wouldn't call it a treaty because that's already presupposing the instrument, so they call it an instrument. And then we worry about later what that's going to look like. So I learned. And so they said, we're thinking of drafting an instrument of some sort. Could be model law, could be model notes, who knows, could be a treaty, a convention, on the subject of enforcing mediated settlement agreements across border. And we heard something, a little something about that. Could I talk with you about that? And that's how the origin. So what I soon learned, what Tim was doing, was that he was contacting a bunch of people around the country he also did not know in order to assess whether or not this was a viable project to propose to UNTRATRO, because they were busy trying to develop proposals for future work. And so he spent several months contacting people, talking to people, getting information, developing drafts, circulating those drafts among at least some of us to comment on those drafts, and then eventually, a few months later, proposing it to UNTRATRO as a new project. And so they decided, okay, we'll consider it. So then I get to go to my first meeting of UNTRATRO. So 2 of you raised your hand. I went to them for 3 years. They were really quite fascinating. because by way of background, I look at this through two lenses. My expertise and research is all in dispute resolution, mediation, international mediation, private dispute resolution, public dispute resolution, mediation representation, and negotiation. So I looked at it through that lens. I also teach first-year contracts, I taught sales, I taught international business transactions. So I got to see it through a second lens, and that's the lens of someone that knows a little bit about the substance. So I show up in this meeting that looks like a General Assembly style type facility, and there's a guy named Michael Schneider from Switzerland who is chairing this. You know, this looks like some of you know Michael. That day I did not like him. We got to be very good friends. He's a really interesting guy if you don't know him. Very bright guy, very sharp, a little intimidating. So he's running this meeting with the one choice. Is there going to be adopt this as a project? So you asked about origins. The question was, will we even look at this? So we're sitting there in this room, and I'm new to this process, watching this. I don't know him at all. And I heard he's been around. He knows what he's doing, and I could see he's very substantive. And he's being very careful about where he feels about this, because I turned to Tim, and I said to Tim a question that any of us would ask if you don't know this process. So when do they vote? Right, and I got this, we mean vote, we don't vote. I said, how can you have a process that doesn't vote? Well, we do things by consensus. Okay, so this is going to be interesting. So I said, so how are you going to know whether they're going to adopt this project? And he says, well, Michael Schneider will get a feel for the group and we'll just decide consensus or not. And we go, wow, okay, and when's he going to do that? I said, well, we'll have 5 days of meetings first. So the meetings start. And we're having these debates and discussions, and people are presenting issues, and I presented one particular issue that I was very concerned about, and he was terrific. He would drill down on people, and then during the breaks, the dispute resolution people get together, and we really think we're really good at reading body language, and we're trying to read his body language and tone, and we could not figure out where he's coming from on this, and whether he was for or against. He was pretty good at keeping that. Some days we'd say, he doesn't like this idea, and it's going to go down. And then we thought, oh, he likes it, it's going to be good. So we had no idea, and I was clearly in favor of moving ahead with this, and was hoping that was what would happen. So that's how the process got started. So then he did declare consensus. He was not enthusiastic about the project, but he was a good trooper about it and proceeded and participated throughout the 3-year process in a very substantive and useful way. Like I said, he had a lot to contribute, but he did declare consensus. And then the next thing that happens is that gets assigned to a group called, in this case, Working Group 2. And so 2 gets assigned it because they do arbitrations, but this is mediation. So that became the second origin issue we had to deal with, and that was, in the room, you have 60 country delegations, along with the members of the delegation, so there's probably 70, 80 people there. Then you got the NGOs, and there's a lot of NGO participation, so you probably had another 20, 30 there, and you had over 100 plus people sitting in this room discussing what they're going to do and whether to go ahead with this. And we're trying to figure out, and the process begins by being signed to this group, and they start a drafting process. And no one knows what's going to happen. All we're doing is working off some ideas that eventually becomes a draft, that eventually becomes a convention, and over a 3-year drafting period, that's what happened. And the result was that by the end of 3 years, there were 2 instruments that was created. One instrument was the convention, a treaty that was open for signature in Singapore in early August. And the other is a model law for those countries who are not quite ready for the treaty. There's another question we're going to be asked later on, what are the keys to successful treaty making. At that point, I'll talk about some of the ins and outs of how that came about.
Hal, do you want to just mention the number of signatories, because people have been remarking about how successful it's been for the participation?
That's an interesting question to raise here with this very sophisticated group, because I was asked that question a lot as it was happening in real time. You were there. You saw the outside pictures of it. I was getting real-time reports as it was happening. It's people seeing pictures, people standing there. 46 signatures. People are like ecstatic, and I go, wait a second. What does that mean? I mean, isn't there a difference between signature and ratification? And I still don't have an answer. Could you answer that for me? So what? And that's not and that's a serious question. I know, and that's a really serious question. So what? Because none of them ratified it, and it takes 3 people. You have to have 3 countries to ratify it. and file instruments, and then 6 months after that, the treaty becomes effective. So people are running around saying, wow, we got a treaty, we don't have anything. So could you explain that to me?
Let's put it in the basket of necessary but not sufficient. But the sensibility of that momentum that actually
Yes.
pushes the signatories into the ratification, I think it was just really a barometer for a lot of appetite for the Singapore Convention and multilateralism in general, at least the sensibility.
Okay,
of
that's
it.
the way it's being interpreted.
So that's it. But I
Okay.
think the chief lesson you learned was not to play poker with Michael Schneider. Is that fair?
I became a big fan of Mike Schneider. We had a lot of fun together to debate with him. Yes, but you're right. When I play poker with him, he's a very, but I would love to have any kind of discussion with him. We would have very lively discussions, and we would sit there in front of a computer, and he'd be doing fact checks right there. And we'd be going back and forth.
So we'll circle back, obviously, on successful treaty making, but one final table setting with you, Sean. ILC, obviously a critical forum for, if you think about it, incubator for treaty making, multilateral discussions, negotiations. Could you tell us a bit about the conversations around the Convention Against Genocide?
Crimes against humanity,
Crimes
actually.
against humanity, sorry.
Well, I suppose for all four of these projects, you might start with the idea that at the outset, there's a sense that there's a lacuna of some kind in the field of international law, and further, some sense that that lacuna is best filled by a treaty instrument. I think those are two pretty important components. In my particular situation, the lacuna was we have no global treaty focused on crimes against humanity in the context of building up national law and national jurisdiction. We've got a genocide convention, we've got the 1949 Geneva Conventions addressing war crimes. We don't have a global treaty on crimes against humanity focused on national laws, national jurisdiction, and so on. So one interesting aspect of the origins of the ILC's project, I think, is that probably the start was an academic article. In the mid-1990s, Sharif Bassiouni, in the midst of the creation of the ICTY and the ICTR, asked the question, okay, it's great to do the international courts, but why don't we have a treaty on crimes against humanity of this type? So for all of you who are presenting here at the research forum with some idea of something that needs to be done, perhaps take some solace in the possibility that that will lead to something in due course. After the ICC is set up and the Rome Statute enters into force, a civil society group got together under the auspices of Washington University, St. Louis, and said, look, we think this is a good idea that Bassiouni had. Can we carry it even further? And so they got together a bunch of people, academics, former UN legal counsel, former prosecutors at the international courts, to do a sort of steering committee for a Crimes Against Humanity initiative. And they actually go so far as to draft what such a treaty would look like, and then to translate it into multiple languages to see what other people think about it. So I show up on the International Law Commission, newly elected summer of 2012, and one thing I was wondering is, how do we get our topics exactly? And if you look at the ILC's statute, it envisages the UN General Assembly sending projects to the ILC that the Assembly would find of use. Well, the Assembly has done that once or twice, but for most of the life of the International Law Commission, the topics have come from the members themselves. So I said, well, what would be a good topic for me to propose? And knowing this history of the lead up to my being on the ILC, I decided to propose within the Commission the topic of crimes against humanity, expressly for the purpose of developing a convention on prevention and punishment of crimes against humanity. It takes 2 summers for me to persuade my colleagues, because there's a little bit of uncertainty and confusion. How does this relate to the Rome Statute? Will it harm the ICC to have such a project move forward? Ultimately, though, my colleagues thought it was a good idea, so they appoint me special rapporteur, and I produce a series of reports that the ILC debates on an annual basis, developing draft articles and commentary. And this past summer, 2019, we developed the final set of draft articles on prevention and punishment of crimes against humanity with commentary, and we've now sent that forward to the General Assembly. So that's, the origin story, and I'll just finish with answering the question, how did this origin shape, the basic idea and the concept? Well, I think it was a nice thing to have the academic and civil society involvement early in the project. I think it helped promote the visibility of the project. At the end of the day, I think the commission narrowed the scope of the project from what had been envisaged earlier, probably because part of that origin story is the ILC being in a symbiotic relationship with governments. And this is also a little different from the other projects. We have the experts of the ILC who are not government representatives writing this thing, figuring out what we think is the best type of convention to have. But we're also on an annual basis sending it to governments and getting government reactions. So we could have gone off, on the deep end with all sorts of bells and whistles and so on, but it would have run into issues in New York for us to do that. So although we're doing our expert thing in Geneva, we've got the practical realities and politics of New York that is refining the project as it moves forward to the point where we now send this thing to New York for governments to take up.
So Sean, I want to stay with you for a minute on the ILC and this incubator idea. Now, obviously, their projects have many different life cycles in the ILC and many different end products. So in some instances, you have, for example, the Rome Statute, where you have a full-fledged treaty that emerges. In others, articles stay as draft articles, although they can certainly be influential. I think the draft articles on state responsibility are obviously key and cornerstone in terms of thinking about international law norms. What, in your mind, especially given the dynamic you've just described between New York and what's going on in the academic sense of discussing the treaty, what in your mind are the critical factors to determine the pathway of a particular project, whether it ends up in a treaty, whether it stays draft articles, or basically extinguishes?
Yeah, so one observation would be that because multilateral treaty making has become rather difficult, difficult to get states to do a negotiation, difficult to get them to adopt, difficult to get them to sign in some situations, difficult to ratify, difficult to then implement. The ILC has moved in a direction where we're doing a lot of projects that we don't even call draft articles, right? So conclusions on customary international law, guide to practice on reservations to treaties, principles on armed conflict in the environment, never envisaged at any point in the process to become a treaty. We do still do some things that are draft articles on expulsion of aliens, draft articles on protection of persons in the event of disasters. One critical factor is at the end of our work, we do issue a recommendation to the General Assembly. So taking the issue of the draft articles on responsibility of states, it was not a particularly aggressive, forward-leaning recommendation, turn this into a treaty. Because in particular, the Special Rapporteur, James Crawford, had a view that this might not be the right time to try to turn this into a treaty, maybe never will be the right time. By contrast, on the project on crimes against humanity, I don't know if it's aggressive, but a very forward-leaning ILC recommendation, we think you should turn this into a convention, either by means of a diplomatic conference or negotiation within the General Assembly itself. So one factor is the Commission's own, shall we call it, enthusiasm for turning it into a convention. As it happens right now in the Sixth Committee, the Legal Committee of the General Assembly, the question of whether to turn the draft articles on responsibility of states is still into a convention is still being discussed, with some states very much wanting it, other states resisting it. One reason for resistance is, what if you get a few signatories but not a lot of ratifications? Does that diminish the effect of the articles on state responsibility, which already are getting a fair amount of cachet. By contrast, the draft articles on crimes against humanity, one of the biggest arguments for why that has to be a treaty is because certain aspects of it simply don't work unless it's a treaty. If you're serious about mutual legal assistance between states, if you're serious about extradition among states, some of these things just don't work as articles.
Right.
You know, it's not a customary international law thing, it's a treaty thing. And so that's partly also what influences the outcome, I think.
And you talked about getting an internal reading in the ILC or an internal view. It sounds like, at least initially or even through the years, getting an assessment of what the political will outside of the ILC would be or appetite would be for the form of the project is critical. Is that fair?
Yeah, I think that's right. I think right at the outset we do have our political antenna up, such as it is. What will New York find acceptable, and that does influence the way we package the product as well as then send the product forward. I would say, just as a last note, at the outset, by saying this is going to be draft articles for what we plan to be a treaty on crimes against humanity, it was enormously liberating within the commission, because the goal was not to figure out what is settled customary international law, which can lead to all sorts of dust-ups and arguments back and forth. It was, you know, we're writing a treaty and states will either accept it or reject it, and that, in a way, was, you know, very liberating.
No, I can imagine what the ILC calls progressive development is an anathema to many states. So I want to go back to the two successful examples at this stage of treaty making. So we have the Hague Convention, the Singapore Convention, and notwithstanding your reservations. But Michael, let me turn back to you. You mentioned it a bit in your opening remarks about the dynamics in the Hague Convention. But can you give us a sense of what, in your view, were the critical points, the junctures where you thought that either the legal or political questions could have gone either way, and how you overcame them and why?
Well, sure. The shortest answer to that question is up until the last minute.
Yeah.
Interestingly, and this is why I tried to address the various bodies where the treaty was negotiated. Throughout the end of the special commission process, where experts were there selected by governments, but they weren't necessarily guided by governments at that stage. And this picks up a bit on some of the points Sean was making, I think, which was, you would have experts, some who were practitioners, some who were academics, some who were government representatives, but they would often express their views as to the world in which, as it should be. I think by the time we got to the diplomatic session, there was enough realization that the perfect instrument might have multiple signatures, might have 0 signatures, but might not have any ratifications or might not make any bit of a difference. So by the time we got to the diplomatic session, we were able to get beyond a lot of these issues, actually all the issues, I think, and there was a willingness to be flexible. It was either because you had directions from the governments saying we want an answer, or we want an instrument, or there was a realization that we're about to get an instrument if we play this right. So there was a great deal of flexibility that had not existed in the prior stages. So it was very helpful to have this more open government type process. And that's not always the case in other bodies, I certainly would recognize.
And Hal, what about you? We spoke a bit about what lessons learned there could be. I realize that there's not a comparative perspective that you would bring to it. But from your perspective, where was the Singapore Convention? What were critical moments there?
Well, I thought there was a number of critical moments because I looked at it through a dispute resolution process, so I could see this through a framework that probably everyone's living, but I could see it through this academic framework. And the academic framework was two things that come to mind, actually several things, but two. One is they did come in authority, a lot of the governments, and that was a problem. That was a problem because they were not, they would have authority for that week. And so you could see that they were constrained, and I could go through some examples of that, where they were limited in their movement because they had directions from back home, and that was a little frustrating. Except for Michael Schneider, I don't know who gives him direction. I think he's a free agent, but you may know better than I do. But a lot of the countries did have constraints. And then we had the dynamic of the EU, which probably at any time had about 20 EU, maybe 15 EU members on the floor. But they were meeting every morning and coordinating their view of what they're going to do that day. And then they would meet the next morning and review what happened, and then discuss what they're going to do that day. So you really didn't have like 20 people that you could really work with, because all the shots were being called by in Brussels and the EU representatives. As I said to Michael today, because we know these people, and some of you may know Noel from the EU, and I told him this. I said, the first couple of meetings, I was really learning to dislike you, because he was like calling all the shots from there. You could just see him. I was waiting for these signals from his nose or whatever. And it was very frustrating, because you see the progressing, and then he would just give his wink or whatever he's doing, and it was over. But fortunately, thanks to Tim, actually, at the State Department, who did a spectacular job, a lot of people did spectacular work, actually, in my view, we got to know people at night, and you spend time with them, and in dispute resolution, we always talk about the value relationships, and boy, as people here, I'm sure, have seen from their own experiences, it makes a huge difference. And I got to know him, Noel. I thought he was terrific. He was a bright guy. He had a job to do, and he ultimately was responsible for the final resolution. And that gets to a second lesson from this. The first is, you do have the issue of authority, and then people working together and finding out, in dispute resolution and multi-party processes. I'm sorry for those people who are not schooled in this area. We talk a lot about coalitions and how they develop alliances, and how coalitions can cause problems in multi-party processes, and all that was going on here. And you had this huge coalition called the EU that was causing a lot of disruption. On the other hand, he was a bright guy, and he was someone you could talk to on this particular set of issues. So then the second dynamic was, and again, this is my dispute resolution language issues, you'd hear these proposals that would be called compromises. Now, if I had more time, I'd ask people what your definition of compromise is. Different people have different views of that word. I happen to hate the word. I know it's strong language, but the reason I don't like the word is because it suggests to people that we have to give up something and just find a middle ground and give up what's important to me. And I think that's a bad negotiation process if everyone has to come in there and say, okay, the only way we're going to succeed is I have to give up stuff. It's a very negative perspective on dispute resolution. And so I really disliked the word, but then the more I listened to the way those proposals were presented, I realized they were not compromising the way I thought of that language. They were really intelligent, interest-based proposals being presented, saying, okay, you have this concern, here's a proposal that can meet all our different interests. It may not be your ideal proposal, but it'll meet your primary interest. People had to finally decide what was really important to them. And so the way the process worked is that you ended up the first couple years, and this was also a very smart move on the Untitled process, or the drafting group process, working group process. They started with the easier issues. And that's smart from a negotiation point of view. So they're starting with the easier issues, and they're building up, and by the time 2.5 years later, we get to the contentious issues, which we all knew was waiting out there. And you said you didn't know till the last minute. We didn't know till the last minute either, because we knew that there was a day of reckoning coming. And we didn't know what was going to happen. And what saved us is a snowstorm and the UN getting closed down. So we had
literal
a
snowstorm.
What?
A literal snowstorm.
Literally. No, it got snowed down. No, the UN got closed. It got closed. It was really, we thought we were making some motion here, movement. We were at the point where we think we're now going to get to these most contentious issues, and a snowstorm hits, and they literally closed New York City, including the UN. And so what do we do now? And we only got another day left in this 5-day session. So people met. People met at a law firm near the UN, and that's where for those that are fans of Hamilton, this is the room where it happened. And it was the room where it happened. So they developed what became known as the 5-element compromise. And the compromise dealt with the most contentious issues. And they did it, I think, and we don't have time here to go into how they were shaped, but they were, read my article, not as fancy a title, but it covers it, called Key Choices, and how these choices were made is part of this 5-element compromise. And the reason I think the process ultimately worked, from my point of view, as an observer, is people were really acting in good faith. They really were working together, trying to figure out how to solve this. It was not a highly political issue that goes on in some of the other rooms of the UN, so that probably made it a lot easier. And as a result, the sense I got from other people is that 3 years from beginning to end, less than 3 years from beginning to end, is pretty record kind of accomplishment.
Certainly. So, Cymie, let me turn to you. BB&J is in a very different place at this stage. How would you define success, and can you address some of the legal and political factors that you think could lead to success or break negotiations, as it may be?
So I think for the BB&J treaty, it's actually not called a treaty, technically. It's an international legally binding instrument.
Yeah,
Once
right.
again, yeah. But at least legally binding. So it's going to cover nearly half the surface of the planet, and given the depth of the ocean water, it's considerably more living space than the rest of the planet. It's a huge task, and there's massive uncertainty about what this system is that we're supposed to be creating rules to manage. So for it to be a successful treaty, other than just for some people, success would be have a piece of paper that everybody signs at the outset. But I don't think that that's success. It has to be additional to what we have in the Convention on the Law of the Sea. It has to, for me, the ideal is a system that sets down the basics, the principles, some rules, and most importantly, appropriate institutions so that we can build, as we get more knowledge and we get better at managing the space, that we can actually build on what we're doing there. And there's a tension between the concern that if it's too skeletal, if it's too bare bones, it won't be effective, it won't be meaningful, because you'll have to gin up the political will to do annexes or protocols or whatever further work you need to do to develop it, but you need the flexibility to do that. I thought there's a very nice piece by Alan Boyle in the OUP Handbook on International Treaties that came out this year that talks about this dynamic in treaty making. So I think that's what we need. Because we need institutions, that means we need to have the key players in this space participating. So the major maritime countries, the Pacific Island states, the small island states, that they need to be in on this so that the institutions can function. It's different from UNCLOS. The U.S. isn't a party to UNCLOS, but we accept the basic rules as customary international law. And while it means we're shut out of the institutions it creates, the Law of the Sea Tribunal, the International Seabed Authority, that's not gotten to be a serious problem. Here, I don't think if those major countries are not party, that's going to be a big problem. And I think it's very challenging. I mean, there are clearly conflicting interests. So far, the process, we only had negotiating text before the delegations at the last meeting in August, and we only have one more meeting. And probably half of that, should we get text, final text, needs to be used to fine-tune the language and go through all the procedures to actually adopt a treaty. So it's going to be hard. I can go on longer, but I don't know if we have time to.
Now, there's obviously a lot to say. We could circle back when we talk about kind of the crystal ball gazing. But before we do that, Sean, where do you think the Crimes Against Humanity project is going and why?
So as I said before, the International Law Commission finished its work in August on the draft articles on prevention and punishment of crimes against humanity, sent it to the General Assembly in September as a part of our annual report. And 2 weeks ago here in New York, in the Sixth Committee, the Legal Committee, about 70 to 75 states spoke in the Sixth Committee about the project. I would say about 50 of those states were highly supportive of it being a convention, including the entire European Union set of states. I would say about 15 of those states did not signal clearly one way or the other whether they supported a convention, and then maybe about 10 expressed reservations. None of those 10 said absolutely not, no convention, but it's diplomatic diplomatic speak. Some were saying, let's delay this, let's talk about it more, things of that sort. So there's been this debate. Within the next 2 or 3 weeks, there will be a General Assembly resolution specifically on this topic. Whenever the Commission finishes a project, there's a dedicated resolution about it. So the General Assembly will have to decide something. Options would be, let's go forward with a diplomatic negotiation to take the draft articles that are sort of 95% a treaty and let's finish it off. Option on the other end of the spectrum is, thank you very much, ILC, for your work. Very interesting. Let's
shelve it.
Put it on a shelf and come back to it at some future point. And then there's options in the middle, and that may be where things end up. We'll see. It's always possible to establish an ad hoc group or a working group that will analyze the text, come back with a recommendation to the Sixth Committee. There might be a time limit on that. There might not be. So we'll have to see. I'll finish off, though, by just saying I agree entirely with Cymie that getting a piece of paper done and out the door isn't really the objective here. The objective is to have a meaningful effect in the field that you're trying to address. And for the Crimes Against Humanity project, the objective is not just to get a treaty and not just to get the ratifications even, but to get the implementation in national law, to get a national law on crimes against humanity adopted. For example, there is no such law in the United States. To get it adopted, to get states to adopt jurisdiction over offenders, and that includes not just your own people, but the people who turn up in your territory, who committed those bad acts somewhere else, to do things like create jurisdiction in the International Court of Justice. Why is Bosnia suing Serbia for genocide and not crimes against humanity? The answer is there's a genocide convention and there's no crimes against humanity convention. So the goal is to get states to implement the instrument at the end of the day. That's what I would view as success.
So Sean, before I leave you, in terms of the recent Sixth Committee statements, where did the U.S. fall on the spectrum?
So the U.S. was probably in that last category of states that had questions, concerns, wanted to discuss the matter further, was not prepared to join a group that would say, let's do a convention now, but was also not saying no, never, bad idea, anything like that.
Okay. So let me switch gears, and Michael, turn to you, because I want to talk a bit about the intersection between national politics and the exercise of multilateral treaty making. So the 2019 Hague Convention obviously is an example of the U.S. having a substantial participation in that process. Some might call it a rare event, getting rarer still. Can you tell us why you think that there was such substantial U.S. participation in the 2019 Hague Convention?
Sure, and again, these are my own views. At the outset, it's to sort of debunk part of the question. I would offer two thoughts. One, private international law, as you're hearing, this end of the table, is unique. It's in many respects a little less ambitious than public international law, where you're trying to to change some aspect of government practice or the rules for the world instead of addressing the conduct of private actors. That said, last month, the U.S. deposited its instrument of ratification for the UN Receivables Convention. The convention is not in force. I think you need 5 countries to have deposited. We're at 2. It's a noteworthy event, particularly in light of the question itself. I don't know the answer to whether and when the U.S. will sign the Judgements Convention. That a decision would still need to be made pursuant to our own internal processes. But the important factors here will be that, again, the U.S. had proposed this work because we think it is beneficial to U.S. litigants, where the U.S. courts are going to recognize and enforce foreign judgments, but reciprocity has been lacking. So we see a certain benefit to possibly having the U.S. court orders recognized. So we're hopeful that will factor into the decision making, and should the U.S. become party and a significant number of other countries become party, this is going to help U.S. parties, and it's going to decrease the cost of litigation.
And how optimistic are you outside the sphere of private international law in terms of U.S. participation?
A little less so, or at least a little less so. I think it's important to note that, at least in the private international law realm, you're talking about discrete topics. You're looking at either harmonizing rules or trying to address conflicts rules, where there is a great interest for this. This will benefit U.S. actors and the U.S. economy. And often with very little change to what is U.S. practice. I'm not sure that what I'm hearing at the other end of the table fits into that universe. So I suspect, at least for the intermediate period, I don't see that necessarily changing.
All right, so I also want to leave time for the audience to ask questions, but let's round this up and get basic and end where we began, which is really the fundamental question of the continued utility of multilateral treaty making in meeting today's biggest global challenges. What do you think they're still useful, and if so, in what circumstances? And I'll start with whoever wants to jump at that.
Well, go ahead.
Well, I'll jump. Why not? I think that some of the challenges to multilateral treaty making is that we have already addressed many aspects of international law with treaty instruments, and therefore it becomes a little less obvious that you must have a new treaty to address further issues. I think a second challenge is that many of the problems we're facing are rapidly changing. The problems themselves are rapidly changing. So take cyber issues maybe as an example. It seems like every year, if not every month, there's some new phenomenon occurring that feels like we need to address it in some way. And treaty instruments are so static in nature and take so long to develop typically that they aren't an especially sophisticated way of addressing the global problems that we have. Having said all that, I do think that there remain issues that are uniquely to be addressed through treaties as a very formal way of coordinating state behavior, particularly in circumstances where you need to alter national law, and it may well be you need that written document that parliaments and congresses and others can look at and use to alter their national system. I indicated on the Crimes Against Humanity project that in some respects it just doesn't work if you don't alter the national law. And I think there's still realms where we'll find that to be true. I'll just finish by noting that, and I'll jump into Cymie's domain here with the Law of the Sea Convention, that we've become creative in our treaty making now. the idea of a framework agreement that could have supplemental agreements to it. A framework agreement that might allow for alterations by a conference of the parties. In the context of the Law of the Sea Convention, provisions that talk about international standards that allow you to calibrate the treaty obligation on the basis of something else like an IMO, International Maritime Organization, set of standards. That I think what's interesting is that we have, it's not an all one or the other. It's not static treaty or, soft law. It's a way of calibrating among those two polar opposites. I think we've got tools there that we can harness and use.
Cymie?
So I think for BB&J, it illustrates a certain kind of treaty that needs some kind of, as I mentioned, institution, and for that you need a treaty. You need to have an international organization. You need to constitute it. So you need a constitutional document. I think we can look at what we've gotten out of soft law for the issues that BB&J deals with, and we've got the UN General Assembly resolutions. We've got Sustainable Development Goal 14, life underwater. Those clearly aren't sufficient to get real change in regulating activities in the ocean. There's another element to the BB&J problem, which I didn't mention, but the Division of Ocean Affairs and Law of the Sea at the UN came up with a list of over 70 international agreements that affect this region, and there's certainly far more than that if you take a broader scope than they did. And those different bodies and regimes have to be coordinated. That's one of the challenging problems that the negotiation is facing. If it's successful, it'll establish relations between those bodies that are cooperative, coordinating, almost maybe kind of federalism arrangement or something. And you can't do that without a treaty. But the final thing I'd say is I absolutely agree with Sean that implementation is done through national law. And so to the extent to which having a treaty facilitates that part of the process is really important. FAO has done some very valuable, Food and Agriculture Organization has done some valuable work in coming up with non-treaty guidelines for marine affairs, fisheries issues that have been effective. But for something this complex, I think you need the treaty mechanism.
Hal?
Well, I think Michael made an excellent point about, I don't know if the seeing was purposeful. You got the public side here and the private side over here. I did do a textbook a number of years ago which was designed to bring the public and private together. It was called International Conflict Resolution, and half of it's on public and private because they tend not to talk to each other. So nice to bring us all together here. Yeah, nice to meet you guys. So I think these issues probably are easier. I had viewed, as again, observer of this process, it felt like to me, I don't want this comment to view diminished at all the significance of the work that was done or the quality of the people, because I was very impressed with the quality of people. It felt like to me it was like a diplomat in training program. There's something called the Dartmouth College, and I mentioned that to you, Dartmouth Project, which I won't go into, had during the Soviet period, about how do you get people talking to each other on non-controversial issues so that when they have to deal with controversial issues, they at least have relationships in which they can then function through those relationships. And I felt a lot of that was going on here. If they had removed the diplomatic language in this process, we could have done these meetings in 2 days instead of 5. I mean, everyone was always, very careful about their expression of points and being respectful of each other, which was quite impressive. And I felt there's a lot of, so I think in terms of the multilateral process, I think there's benefits to bring people together to talk to each other and work on less controversial projects that could then equip them for more controversial projects. They did have a very significant compromise here that the EU was responsible for that I thought was brilliantly done. And that is we had 2 instruments. We have a convention and a model law. They were done simultaneously. Michael said, well, that was impressive, you did both, but it was really a result of trying to get buy-in for everybody in the room. So for those people that are ready for ratification, we have a convention. For those that want to experiment a little bit with a model law locally, we got that too. It all involved the same intellectual energy to produce both documents. So now you had both choices, and as a result, we could get through the convention and get something done in 3 years. I want to end just making a plug to the people in this room, because I understand this, you're working on works in progress. It's about publications and a lot of academics here. And that's the value of writing in terms of thinking long-term and not short-term. You mentioned already the example of a piece that was done many years ago that's now becoming the basis for some of the work you're doing now. You just never know when the work is going to become relevant. You pray and hope your work will become relevant. But I think it's important to think of scholarship long-term, and I mentioned that because of one of the things that came out of the Singapore project. We did develop a book called the Singapore Reference Book that will be coming out very soon. It is 15 chapters written by different people that helped draft different provisions in Untitled, with the idea that this could be a useful reference book, whether it's going to be useful today or 5 years from now or 30 years from now. We have now contemporaneous development of ideas at the time the treaty was put together, so that whether we get ratification this year by 3 countries or 10 years from now, and I think it will happen at some point, I just don't know how long it's going to be, they'll have some source to look at that hopefully will give them some insight into why the choices were made that were made. So I think as scholars we have to think long-term and not short-term.
Thanks. And Michael?
So I can wrap this up. So again, private international law is quite unique. Most of the focus is on conflicts of law and to some degree harmonization. One of the questions that at least I would consistently ask when presented with a new project, and I'm glad the Europeans did in the context of the Singapore Convention, is why a treaty? Do you need a treaty? There's not necessarily an allergy to a treaty, but certainly from a U.S. perspective, it takes a while. Once you conclude a treaty to bring it into force. Take, for example, the Child Support Convention, which is incredibly consistent with U.S. law, another result of a U.S. proposal. It was finalized in 2007 and entered into force for the United States in 2017. And this is something that there was no or limited opposition. We just had to deal with a lot of federalism issues and get the Congress to act, the states to act, et cetera. The answer to the question why a treaty, at least in the private international law realm, might be twofold. One is if you want reciprocity in a meaningful way, you can get reciprocity through domestic law, but you can't necessarily point to it and say, I have a right to this reciprocity the way you can if you have a treaty relationship. And the other might be some degree of cooperation, at least in the conventions coming out of the Hague Conference. There are central authorities that allow for governmental interaction with respect to the implementation of the convention. Where you need that, a treaty might be a little more helpful. But short of that, soft law does provide a lot of good opportunities. And soft law, at least in the private international law realm, has taken the form of model laws, perhaps principles for domestic law. The key benefits are that it's easier to enact a model law because you don't have to stick to that text precisely, although you should be as consistent as possible. It's not viewed as necessarily some international organization saying these are the rules that you have to adopt, so it becomes a little more palatable to some. But it's also a good foundation for the future. It may very well be that Sean had indicated that there are conventions that have, most of the difficult issues or the relevant issues have already been addressed to some degree. If you can identify an issue that needs to develop a little more, data protection, for example, it may help to have a little bit more development domestically before you look to the establishment of some international rules in the form of a treaty. I would say in the negotiation of the Judgements Convention, that was quite helpful to actually have delegates come and speak to their relevant experiences in the various areas that were covered by the convention. So sometimes if you start with the soft law instrument, you develop practice where you can ultimately get to a convention. Now, of course, the risk there is you're going to have the potential for a lack of uniformity if you don't have the obligation to necessarily comply. And then there's the reality, which is, at least if you're talking about international organizations, some countries don't like soft law because they want to see, and this would be a government perspective perhaps, although it could be a taxpayer perspective as well, which is if you're putting a lot of money into these organizations, you want rules coming out, or some countries want to see hard rules coming out because it's easier to justify the continuation of the relationship with that organization.
Thanks, Michael. So we have chance for, I think, a couple of questions from the audience. Yeah, Julian.
So I just have a question about the consensus rule. So when I was a law student, Georg Nolte at the ILC told me that consensus was the most difficult thing to explain in international law, and I had no earthly idea what he meant. And it was actually going to Untitled where I understood what on earth is this? And I'm curious, actually, if there are differences in how you have all sort of perceived the consensus rule. Who does consensus empower? Who does consensus help? How does consensus work in your different institutions? I don't know if all of you feel like you can talk about that right now, but yeah.
Yeah, awkward.
Is there anyone who wants to talk about? Yeah, please.
That's a great question. I contemplated jumping in on that just to make a clarification anyway. And consensus is what the relevant body determines it to be. In a lot of the public international law realm where I've had experience, in the national security or international security realms, for example, you see consensus being unanimity. One veto or one objection defeats consensus. In the private international law realm, as Hal had indicated, it's consensus when you see it. You often have a chair who will come and say, I think I am hearing the room say X. I think there's an emerging consensus here. And that gives states the ability to object to it. That said, I have lost, if you keep score, I tend not to, but on some issues have gone against the position I've taken, where you can have a room with 40 delegates, or 40 countries represented, and 3 have spoken. Me in one direction, and then two people in another. The thought being that other countries could speak up if they really cared about the issue or cared to shift that. Consensus played an interesting role, I think, in the finalization of the Judgements Convention in particular, which was, it got flipped around sometimes. Sometimes there was are you going to object to the finalization of this convention? Are you going to be the one who's going to do that? And it put some delegations in awkward positions. But at the same time, you also had some proponents for proposals realizing there wasn't adequate support. We want to retain goodwill. We're just going to withdraw a proposal because we don't have enough support. There's not consensus around this, and we showed flexibility actually as well in that area, because it's you need to choose what's important and hope you're not going to lose on a consensus determination on something that's really important.
Let me add something to that, because there are formal distinctions here in terms of multi-party processes, and people sometimes get confused between being unanimous and consensus, and they sound similar, but they're actually quite different. And so think about this next time you're in a meeting with somebody. Instead of saying someone, does everyone endorse this idea, can you live with it? And live with it is the standard for consensus. And it was used in South Africa when they adopted the constitution there. In the post-apartheid period, it was used in Northern Ireland when they developed the peace process there with Mitchell. It's not an uncommon process, and it really is a very different way of looking at the choice. And the reason it's so different is because it feels different when you're saying, am I endorsing it, or can I live with it? And there's a lot more we can live with than endorse. And it makes it a lot easier when going back home to your home countries and saying to people, look, this was an issue I didn't agree with. I didn't like the result, but there were other bigger issues, so we can live with it. So,
just a quick comment. So the preparatory committee meetings for BB&J were all recorded and published on UN webcast, and you can go back to the final PrepCom meeting for the final hours, and if they were still recording, you might be able to see what happened. There was one country that has consistently said the equivalent of no to pretty much everything, but came along under a consensus rule. And it's also a matter of a lot of discussion when you're drafting a treaty. What are going to be the voting rules? What are the procedural rules? Or are you going to leave the procedural rules to be adopted subsequently?
Sean, do you want the final word?
Just, I hope there's at least a consensus that this was a good panel.
And on that
I
note,
want an
thank you.
endorsement.